to the cloud that's recently settled over the Middlesex District Attorney's Office. The Boston Globe recently obtained medical records in the case of 6-month-old Nathan Wilson, who died in 2010. At first, forensic pathologist Peter Cummings ruled his death a homicide, the result of shaken baby syndrome. And Nathan's father, Jeffrey, was charged with his murder. But later, experts hired by the defense found a rare genetic defect that made members of the family prone to ruptures of veins and arteries. And Cummings amended the death certificate, changing the cause of death from homicide to could not be determined. 48 days later, Ryan dropped the murder charges. In notes Cummings wrote before those charges were dropped, he said District Attorney Marian and her staff had not wanted him to change his finding, and said the way they dealt with his case dealt with his office was, quote, unethical and unprofessional. He also said he felt bullied at times and that he was being forced to sign the case out in a way he did not think was honest. Joining me now to address these charges is the District Attorney, Marian. Very good to see you. Thanks so much for being here.
Thanks for having me.
You told Yvonne Abraham in the Globe you were puzzled by the charges, your relations were respectful with the individual and the office. Why would Cummings make such a charge if it wasn't true?
I'm puzzled because I think we can all understand that when people are asking questions, when you make a decision, or more importantly, when they might ask that your boss review your work, you can be disgruntled. People exercise their professional judgment.
Do you have any history of being disgruntled in the time he was there?
I don't know I've never spoke to Dr. Cummings during this, and I don't know him terribly well.
So when she reports in her piece, Yvonne Abraham, that other people familiar with the situation say the relationship between your office and the medical examiner is, quote, toxic, you say that's
I've always had a good relationship with the medical examiner's office. I think they work under difficult conditions with limited resources.
You told Channel 5, District Attorney, at the end of the day, we decided not to go forward with the murder prosecution of a 6-month-old, and didn't I have an obligation to the public and that child before doing that? Even if that's so, don't you have an obligation not to charge someone with murder and have that hang over them for years without a comprehensive investigation beforehand?
Well, so here's where we are. We have a baby, in this case a 6-month-old baby, in the custody of a caretaker, in this case his dad. The child is injured and ultimately dies. Baby goes to the medical examiner's office. There's an autopsy conducted, and the medical examiner rules that the manner of death was homicide and gives that back to us. So we have followed the evidence now. The medical examiner said this is a homicide. This child was killed by inflicted injury.
But my understanding is you arrested the father just hours after the baby was taken off life support. Is that not true?
Based on a number of other pieces of evidence.
But you didn't have all the evidence you just described at that time,
We did
correct?
not have the medical examiner's ruling, although we did have information from the doctors at the hospital.
You know, my sense, District Attorney, is that this would not have been as big a story as it became were it the first time that your relationship with the medical examiner was questioned. You know this in the case of the so-called Cambridge nanny, Aisling Brady McCarthy. 2 years in jail for murder before you dropped the charges. Fairly similar cases, same expert, this Dr. Alice Newton we'll talk about in a minute. So there's a history here. Is that not a fair thing to say?
Well, I think that what you have, and there's two important pieces here. If we all knew in the end what the results of our case were going to be on the day we started the case, that would be useful, but we don't. And in the case of the Brady McCarthy case, we again had a 1-year-old in the care of her nanny.
Correct.
She is taken to the hospital. She lives for several days. She dies. The medical examiner tells us the nanny was only charged initially with assault and battery on that child. We ultimately get a ruling from the medical examiner that for a family that their child has died of homicide. We are then in a position where that was about 4 months after the child had died. We then did those charges. As time progresses, well into the case, the same medical examiner has a change of mind. In that case, the medical examiner herself, there was a review at the medical examiner's office with the peer review, and they then give us an amended death certificate.
Yeah, but in terms of your relationship with the medical examiner's office, again, this Cummings in the first case talked about being, quote, bullied. The lawyers in the Brady McCarthy case were so worried about you exerting undue influence over the medical examiner, they went to the judge to seek an order to bar you from even having contact with the medical examiner, and it was granted. And I have to say, I called a few defense attorneys today. No one has ever heard. That's so extraordinary for an order to be granted. What does that speak to, if not to the fact that there's a concern about your relationship and your attempt to influence inappropriately medical examiners? Isn't that why the judge ruled how the judge ruled?
I don't know why the judge ruled the way the judge ruled. What I know is there was, at some level, an agreement between all the parties that no one would have contact with the medical examiner while they were doing that review. But by statute in Massachusetts, the investigation of deaths in those circumstances is a joint investigation to be conducted by statute by the medical examiner's office and the district attorney's office. So there's nothing untoward about contact between the district attorney's office.
Even though in this case the judge said don't have it anymore.
Well, there was some agreement at some point that all parties, that everybody could submit, and that doctors would work, the doctors could contact anyone they wanted for further information, and then the results of that review would be released.
District Attorney, let's talk about a few elements and then step back a little bit. This Dr. Alice Newton, apparently with MGH, Mass General now, was your chief expert in both cases. We're saying that shaken baby syndrome, or whatever it's called now, child abuse, I don't know.
Abusive head trauma.
Head trauma. You ever going to use her again? Should she be doing these kinds of cases when she was, I was about to say dead wrong, and I'm sorry for the choice of words, but she was. One woman's in jail for 2 years. One guy's life ruined, a father who not only loses a child, but has his reputation destroyed through 4 years of a murder case hanging over his head. Should this woman even be ever consulting with offices like her? Are you ever going to use her again?
Well, I think that what may unfold in the future, or how a child may present at the hospital at some point, is different. What I think we need to be focused on is, in both of these cases, where we got to was that the cause of death was not able to be determined. It was not determined that it was not what it had initially been diagnosed. There was a reason for the judges and for the doctors in both cases. In one case, the family medical history, and in the second, some other information that the doctor later reviewed.
But her expert advice here could have led to two horrible injustices. I guess my question, would you ever use her again? It's a pretty straightforward question. Would you ever use this doctor again in a case like this?
Well, I think in both of those cases, Dr. Newton was involved in the actual treatment of the child when the child was presented at the hospital. Obviously, we're not involved in that choice of what hospital the child goes to.
She's suspect in your eyes going forward?
I think we would have to, we look at everything as we do in any case on its facts.
Can we just step back for a second?
Yes,
sure. What's the moral of the story for you? Even if you believe you did the right thing under the circumstances, even people who don't have expertise in this area, like I have read mountains of articles about how this whole shaken baby syndrome thing, and we couldn't be more sympathetic to any baby that's injured, is a sketchy area. So going forward after these two cases, the Wilson case, the Brady McCarthy case, are you going to operate differently at all in light of what happened?
We are going to operate differently.
Tell us how, if you would, please.
I think that regardless of where you come out in terms of these particular cases, you look at what the result was. I mean, I, as the district attorney, sworn to protect people in the county, and most especially, we'd agree, children. I'm in a circumstance in 1 year where I have to null pros 2 cases where we brought homicide charges. We are always striving and are ethically bound to be getting to a just result. In both of those cases, based on the changes in the rulings as to cause of death, the ethical result was to end those prosecutions.
Understood, but going forward, so how do you change the way you operate?
Going forward, I think there needs to be a collaborative effort on the part of everyone involved in these processes to think through what we're doing. I think peer review is essential. I believe the medical examiner's office agrees with that since they adopted the peer review in the Ainsley-McCarthy case. I think that perhaps the greater use of outside experts early on is important. We need to look at the human and the dollar cost in these kind of situations and avoid that continuing to happen.
Before you go, I just want to say to you that we really appreciate your accepting this invitation, and my guess under these kinds of circumstances, most fellow DAs would not. So thank you so much for being here.
Thank you. Thanks for having me.
Marian, District Attorney, Middlesex County.